Okay, good afternoon. My name is Robert Link. This is Commercial Leases and COVID-19 lease renegotiations using force majeure and frustration of purpose. We're also going to touch on a little Chapter 11 bankruptcy issues and just some other pertinent issues as it relates. We're starting the meeting right now, and I've shut off everybody's video in case we're going to reproduce the video today. I think we plan on putting it on the website a little bit later today. Your audio is also shut off as a default. If you have a question during the presentation, or you think maybe we're going too fast, or you want us to specify something, go ahead and put that question in the chat. And I'm going to try my best while we're doing the presentation to check in with the Zoom chat and make sure we're covering the information that you want covered. I'm going to try to open up the audio at the end of the presentation. And at the end of the presentation, you can ask whatever you want, and hopefully we'll get to those issues. I want to close anyone's video that is up. So I'm going to close that video. Okay, my contact information is there. This is a presentation of David A. Gallo and Associates, LLP. My name is Bobby Link. David Gallo is also with us. That's my email and my cell. The email is the best way to contact me. If you have any questions about the presentation, you want the materials, again, they're going to be on the website later today. But if there's something you want a consultation, we want to discuss about these issues that are unique to you on a one-on-one basis, that's something that we can arrange. And then again, the materials are going to be available on the website later today. So I mentioned my partner, David A. Gallo, is with us. David, why don't you tell us a little bit about your background?
Good afternoon. So I've been practicing for about 40 years, and most of what I do has to do with real estate foreclosures, REO evictions, REO sales, commercial lease litigation, and commercial lease contracts. You can go on our website and you can see my credentials. I don't want to bore you with them now, but thank you for joining us on this commercial lease workout concerning the coronavirus COVID-19 pandemic.
So, I've been admitted for about 10 years. I'm admitted in New York and New Jersey, all the state and the federal courts. My concentration is foreclosure, landlord-tenant, commercial landlord-tenant. We do Yellowstone injunctions here at the firm. We do declaratory judgment actions, any kind of lease disputes, lease renegotiations. Those are things that we handle on a day-to-day basis, some title litigation work, other kind of real property disputes, partition actions, etc. Different trials, evidentiary hearings. We do the drafting of the contracts, but we're also prepared in a position to litigate should that be the case. Obviously, we try to avoid that, and we try to settle where it's appropriate for the respective parties. Okay, so we're going to go to our first slide here. Where do you stand? All right, so right now, we are in New York pause land, executive order number 202.8, that's dated March 7th, 2002. That says that there's a 90-day hold moratorium on evictions and foreclosures. The hold pertains to enforcement, but for all intents and purposes, there's no activity going on with respect to evictions right now. If you're trying to, in your head, kind of plan out, well, if I'm not paying my rent on March 1st, when is this hold going to extend to? You're talking 3 months from March 7th. So that takes you into June, July, March 7th, March, April, May, June. That takes you into June 7th. Then the landlord needs to wait 5 days before the rent is due, before they can send what's called a 14-day notice to quit, or to pay the back arrears. And that time period expires. So that takes you to the end of June. You're looking to maybe, if you're a landlord, get into court in July. That's if New York pause isn't extended, which, in all likelihood could happen. We don't really know at this point. So in the best case scenario, the landlord is going to get you in court probably mid-July. When you appear in court, that's if they're doing in-person appearances, you're going to be able to ask at your first appearance for 2 weeks to obtain an attorney. You'll get that automatic adjournment. It's your right under state statutory law. So you're really looking at August in the best case scenario for the landlord, when they're really going to be able to enforce, under the non-payment statute, the fact that you breach the lease by not paying.
The only thing I'd like to add is that the whole purpose of this webinar is that you don't have to worry about when you have to go back to court. The whole purpose of this is to get you into a forbearance agreement with your tenants. And if to those of you that are tenants, for you to be into a forbearance agreement with your landlord so that you don't have to bother with going to court.
So the guidance that we're getting right now from the courts is stop everything. Now, yesterday, there was a second administrative order from the chief judge, Judge Marks, who kind of sets all the policies and procedures for the court personnel and all the attorneys in the state. And they're starting to experiment with some virtual court appearances, in the essential cases and in some non-essential cases where they're going to be unilaterally reaching out to litigants and trying to settle cases, deciding motions that have been pending. However, in the landlord-tenant context, where you sometimes have calendar calls of 50 litigants or more, it's very hard to see how they're going to do this virtually. So, David, any thoughts on that?
Well, just anyone that's been to landlord-tenant court knows in the boroughs you have multiple parts, and each housing court judge has anywhere from 75 to 150 cases on every day. Those cases have not been on the calendar now for weeks. There are pending cases that are getting adjourned, and then you're going to have new cases being brought. I don't see that this, that's for residential tenants. Commercial parts are just as busy. So I don't, the housing and commercial landlord tenant parts have traditionally been very crowded. People are on top of one another. And it's just, even when they open the courts up, I don't know that necessarily those parts are going to be opened up. And I don't really can't picture how they're going to do this virtually.
Right. I can't see 100 Zoom conferences going on between 200 different litigants every day. But part of the reason why we would look at trying to reach a settlement, whether you're a landlord or a tenant, is you get that predictability, and you're able to open those doors and see how can I protect my business, or as a landlord, how can I guarantee certain payments to get me through this on the other end. So that brings us to what's your goal. Here's some potential resolutions to where your lease negotiations could go. A rent forbearance, but that's essentially, if you're a tenant, that's what you have right now. The New York pause has already accomplished this. The landlord cannot evict you, but your installment payments, everything that is due in March, April, and May is going to be now due on June 8th or whenever pause is extended to. Rent abatement, that means that there's going to be certain payments excused or portions of payments excused, maybe because you couldn't perform, maybe because your landlord, the landlord is trying to assist the tenant in making sure something that's mutually agreeable works out. And then a full-blown lease renegotiation, that's where you're executing an amendment to the lease that reaffirms certain rights and obligations under the lease terms. You can be excusing certain payments. Let's say you have a payment that's excused in year 10. You can advance that if you agree with your landlord, advance those excused payments to maybe this year to help you get through this difficult time. Anything you'd add there, David?
Yeah, so, before we get into the weeds of the forbearance agreement, for those of you who are landlords that have mortgages, on your building, you got to be careful that you don't enter into a rent forbearance, rent abatement, or lease renegotiation agreement that's going to violate your mortgage and inadvertently trigger a default. Even if that is not going to happen, because I think as you renegotiate the leases, or you enter into a forbearance agreement with your tenants, I think the banks are going to understand that this was necessary, at least for the pandemic period. So my only recommendation is that as you're going through this, that you don't do anything that's going to permanently affect the contract, the lease. That what you're doing is helping the tenant out, which we want to do. We want the tenant here tomorrow, but doesn't permanently affect that lease that bank relied upon in granting you the credit. So my recommendation is to limit your forbearance, limit your abatement, and whatever lease renegotiation you're doing, don't do anything that when it comes time to refinance your mortgage, you're going to have a problem for yourself.
Right. All right. And I would add to that this is a negotiation. So you want to take into to account, not only in addition to your personal economic circumstances, the circumstances of your business, or if you're a landlord, the circumstances of you making mortgage payments or whatnot. You want to look at that time frame for eviction and see how that fluctuates. You want to look at the potential for litigation and whether or not you're going to want to be willing to have to actually do additional litigate. I'm letting people, if you're late and you're joining us, I'm just adding you right now to the call. I'm going to post the full meeting on the website later today with all the materials, so you'll be able to start over again. But I have the picture of the chess match, and that's exactly what it is. You want to start to think about this situation steps ahead. What is going to happen with respect to any SBA loan that I've applied for? What is going to happen with respect to when a landlord will be able to send me a rent demand notice? What are my rights under the lease? Do I have a good guy clause? That's why you're going to want to start at the next stage reviewing your lease. David, what kind of provisions am I looking at specifically?
Right. So Bobby, just one step before reviewing the lease.
Sure.
For those of you that are going to entertain forbearance agreements or renegotiating the lease, my recommendation, this is what I've been doing in the few instances that I am representing people right now, is that you enter into a pre-negotiation agreement. And essentially, it's exactly what it sounds like, that you're entering into an agreement where you're clearly setting forth what the purpose of these negotiations are. And the reason you're doing this is you don't want to waive any rights that you may have under the lease. So you'll state that you're not waiving any rights under the lease. You're stating that the discussions are voluntary and either party can pull out anytime they want, and that neither party is making any admissions, that the purpose of this is to try to reach an accord during this pandemic period. And if you have lawyers, and I would suggest that you do, my recommendation is that the lawyers also exchange letters similar to this pre-negotiation agreement, so that it's very, very clear, in case this blows up, that the purpose of this was just to either renegotiate the lease or work out an abatement or forbearance agreement. But now getting to what you were saying, Bobby, yes, the first thing you're going to do is look at your contract. You're going to have many clauses that may be affected by what's going on right now. You could have continuous operation clauses, common area responsibility clauses. Many leases, commercial leases, have obligations of the tenant to mitigate damages. If you're a landlord, you're going to be looking at your loss of income insurance policy, a tenant business interruption insurance. You could have co-tenancy concerns. For instance, you're a delicatessen, and you're a delicatessen in a busy shopping center. and you have a bowling alley on one side of you, you have a movie theater on the other side, an ice cream parlor across the street, and perhaps a gym that's there also, and whatever other retail stores that might be there. Large parking lot, and you're paying probably a pretty good rent for all of this traffic. So, you know, when all the traffic is dead because everything's been shuttered, well, you have a problem on your hands. You're not seeing the kind, even though you're allowed to be open to serve food, takeout food, which is basically what a deli is anyway. You've lost most of the traffic, and the hence the rent that you're paying really isn't commensurate to what you expected. You know, so these are the different types of clauses you want to look at, that your attorney wants to look at, to grapple
David,
with, and to see, you know, how you're going to negotiate with your landlord.
The only thing I wanted to add, the way I see it, it would be important to also look at what the use of the property or the premises is under the lease. So, for example, if you lease the premises to operate, financial services, as opposed to leasing the premises for a sit-down restaurant, or leasing the premises for a deli, or leasing the premises, I mean, I think that's all going to play in your negotiation. David, you agree?
Yes, no, I would definitely agree. You know, this is all important to look at. You know, getting back to the clauses in the lease. For some of you, maybe you're only in the first year of your lease, or maybe further in. A lot of leases, I represent a number of landlords, and the leases that we negotiate typically include rent forgiveness, especially in the beginning of the lease. You know, there's an expense tied into moving from one location to another location. There's a build out, and typically the tenant is looking for some rent forgiveness, and sometimes it's significant. Especially if you're entering into a 10-year lease with your landlord, the landlord may be willing to forgive 3 to 6 months rent, but not necessarily all up front. So if you're in year 2 of your lease and you had a 2-month rent abatement for the first year, and you still have another 3 or 4 months rent abatement, but it's further down the lease, you may want to talk to your landlord, have your attorney talk to your landlord about accelerating that forgiveness to get you through this pandemic, because presumably you'll be, if you're still around, you'll be in a much better position to pay the full rent when the pandemic goes away and life, as we hope will happen, goes back to normal.
Okay, so let's talk about force majeure. That's a clause that may or may not be in your commercial lease. That's an example of a force majeure clause. And essentially what it's protecting against is acts of God. It's saying when there is an act of God, when there is some sort of unforeseeable event, this is these are, what you've contracted to. These are the terms and conditions that you've contracted to. Everything should play out in accordance with that force majeure clause. And there you have Charlton Heston right there. And a definition of epidemic and pandemic. Those are definitions provided by the CDC. Those definitions are important because the first prong in seeing if an force majeure provision is applicable is that the act of God must be specifically included in the force majeure clause. Is there a reference to an epidemic, a pandemic, a government order, or an act of public authority in this case? So I think if your force majeure clause includes any of those references, an epidemic, a pandemic, a government order, something saying, an order saying that you can't operate, or an act of a public authority, then that force majeure clause is going to trigger. The Court of Appeals in that Kel Kim Corporation case that I have listed above has said that the catch-all provision is insufficient to trigger force majeure. So if it says the force majeure applies to epidemic, pandemics, government orders, acts of public authority, and any other huge disaster, any other huge disaster is essentially just meaningless. The court isn't going to read into pandemic or epidemic coverage. The force majeure event must prevent performance under the contract. David, you want to talk
Bobby,
about that?
Bobby, let's just back up a little bit. So the
Sure.
underlying premise here is you have a contract, right?
Right.
And why should we forgive your performance under the contract? The court of appeals, the court of appeals, we respect the underlying decisions, make very clear that we respect contracts, and that we need something really, really unusual to happen in order to break that obligation. And so a force majeure clause excuses a party's non-performance under the contract when there are present extraordinary, unforeseen events preventing the party from doing what they're supposed to do. Now, as Bobby was talking about, when you look, each lease's force majeure clause is different. I can guarantee you that. You have to look to your specific clause to see if it would be applicable as resulting from this pandemic. And there are basically, and Bobby hit the first one, the act of God must specifically be included in your force majeure clause. If that's what you're looking at, it could be an act of God, it could be an act of war, it could be a pandemic. Some of these clauses, however, are not specific, and they talk about events beyond our control. And in New York, at least in our jurisdiction, that's not a good thing, because the clause they strictly construe these clauses. So the clause, getting back to Bobby's first point, the clause must specifically, your force majeure clause must specifically include the event that actually prevents the party's performance under the contract. And again, if it's too broad a clause, the principle here is the courts are not going to use general words, broad words, and then give an expansive meaning to that. We want to hold you to your contract. Therefore, depending upon, I've seen force majeure clauses that are 3 lines long. I've seen force majeure clauses that are 3 pages long.
So let's look at an example. You have the example of the Cal Kim case, which is the Court of Appeals case. Which the Court of Appeals is the highest court in the state of New York. So this would be mandatory authority for any court addressing this issue going forward. In the Cal Kim case, you had a skating rink that was unable to obtain insurance because of some unrest in the reinsurance market. The skating rink was able to show the judge that they had made all of these incredible efforts to obtain insurance, notwithstanding the disruption in the reinsurance market. But the court said ultimately, so sad, too bad. This is not something that's unforeseeable, and it wasn't something that necessarily prevented performance under the contract.
Okay, so with the force majeure clause, you basically have 3 hurdles to get over, and we've touched upon the first one. The clause, the force majeure clause, must include that which is preventing you from performing. The second event has to do with was it really an unforeseeable event? Okay, and where we have the President of the United States telling us that this pandemic was certainly unforeseeable, and where you have the World Health Organization telling us that this is a pandemic and unforeseeable, you probably are going to meet number 2, assuming you can get over number 1. Bobby?
Yeah, I also wanted to say, if you don't have a force majeure provision in your contract, and many of you, probably most of you, in a commercial lease, you don't have a force majeure provision in your lease. There's still the common law doctrine of frustration of purpose and impossibility. So a common law doctrine, David, what is a common law doctrine?
So a common law doctrine is a doctrine that's been adopted by the courts over the years, and it basically the result of precedent from court decisions. The judges.
Right. So essentially, there's no statute.
Right.
There's no constitution that applies here. There's no statute that applies here. There's no regulation that applies here. The judge is making up the law over the course of years and then using those past decisions to guide their decisions so that things are being handled in an even keeled way. So that's where the frustration of purpose doctrine and impossibility derived from. And the reason why, David, I'm using frustration of purpose and impossibility together is because in the majority of decisions, you're seeing courts conflate the two, especially in New York. Frustration and purpose. If I were a tenant in a non-payment suit, I would probably plead as an affirmative defense, frustration of purpose, and then impossibility separately. But for all intents and purposes, the courts treat them as the same defense. You're saying essentially that there was an unforeseeable event, and as a consequence of that unforeseeable event, performance was rendered objectively impossible. And there's a case there if you want to check it out. Was COVID-19 unforeseeable? David was touching on this. The unforeseeable event must be something that could not be foreseen or guarded against in the contract. That's that Court of Appeals case again, Cal Kim. The event is not unforeseeable, where the possibility is anticipated or discussed in the contract. And that's citing a Bank of America case where the Eastern District held that the purpose of a restructuring agreement was not frustrated because the flexibility in the exchange rates in that restructuring agreements was something not only that was foreseeable, it was something that it was discussed as a potential for happening in the contract. So in the context that we find ourselves in front of, in the COVID-19 context, I think a landlord attorney is going to argue that worldwide pandemics are foreseeable. You're going to say, listen, we had SARS, we had MERS, we had Ebola all in a handful of years. How in the world are you going to argue that a pandemic like this is unforeseeable? Now, when that happens, your tenant attorney is going to jump out of his shoes and they're going to say, how is this not unforeseeable? The scope of this shutting down the United States government, shutting down the city of New York is something that we could have never experienced or never anticipated. And it's something that we've never, in fact, seen before. And I would argue that if you were to say that COVID-19 was not, was something that was foreseeable, I would say you've rendered this entire doctrine meaningless. If there was an instance where frustration of purpose, in force majeure, if it's specified in your contract applied, I mean, I think this would be the instance.
All right. So what I'd like to just add there is that whether you're talking about frustration of purpose, impossibility of performance, or availing yourself of the force majeure clause under your contract, you're basically saying this was a totally unforeseeable event, and in fact, you couldn't perform because of it. I mean, it could be an unforeseeable event, and you still may be able to perform. I bring this up. Well, number one, it's part of what you have to demonstrate, but also, the case that Bobby's talking about, Kel Kim. It's a Court of Appeals case, which means it started in the Supreme Court, went up to the Appellate Division, now in the Court of Appeals. It probably was an 8-9 year journey to get there. That's not something that you're looking to do for yourself right now. So when I'm negotiating these forbearance agreements, you are going to use force majeure. You're going to use impossibility of performance. As a negotiating tool to get your landlord's attention to negotiate in good faith with you. Otherwise, you could have years and years of litigation as to whether or not your particular contract falls under this. I'm doing one right now. We're just about done. I'm representing a landlord on a restaurant restaurant chain franchise that in Manhattan, which they're telling me that the franchisor called us up and said, you know, the franchisee is can't afford to pay the rent right now. So I said, all right, well, you know, what are you looking to do? Well, we're looking, at first they were looking for an abatement, and I'll talk about that. But I said, you know what, you're going to have to demonstrate for me in hard figures that, in fact, your client is hurting. And she immediately came back and said, all right, I'll have 2019 figures for you and the 2020 figures for you in about 2 minutes. And I said, okay, well, it's good. She's done her homework. She knows that this is a question that's going to be asked, and it's a very reasonable question to ask. You want to show me that you are hurting. And sure enough, when I looked at the figures 2 minutes later, for the months that were affected, the tenant's business was off about 70%. So I went back to my client. This happened over the course of about a week. That's the other thing. You don't want this to drag out forever. Remember, you're looking to get this forbearance agreement done now so that you're not in court in July and August. So after about a few days of negotiating, we finally came back with, look, we're going, they wanted an abatement. We said no, but we will forbear, defer 2 months rent, for 2 months, half a month's rent. And we'll let you pay it back next year when things presumably are good. I think frankly, that they should have pushed harder on us for a partial abatement. And
that's what I was going to say, David. I mean, if let's say if you're the representing that restaurant franchise, what would you ask for?
Well, I would have asked for a partial abatement because the food that I cannot sell during this pandemic, I'm never going to sell. It's not like I'm an accountant where I have clients that can't come in to see me because we do need face-to-face meetings. Therefore, that business is not taking place right now. When the pandemic is over, the issues that those clients had are still going to be there, and they're still going to go into their accountants. So presumably, the accounting firm should not have lost any business at all. Just they're going to be a lot busier when things get back to normal. That's not
so you're saying, on the contrary, if you have a hamburger stand and the average customer eats 5 hamburgers a month, they're not just going to eat 15 hamburgers in June because the hamburger stand opens up again.
Unless it was a really good hamburger stand.
Right, exactly.
But,
right.
now I'll give you another example. You have perhaps a gym that provides services for working out. They have trainers and they have programs, and you have the owner of the gym goes to the landlord and says, and this is the next matter that I'm working on, says, we don't have look, my business is shut down, nobody can go out. My trainers are shut down. You know, I need and I'm never going to get this business back. We need an abatement of rent. And the first thing we asked was, look, you're showing me you're not making any money right now, but, you know, I mean, have you tried to mitigate your damages? Because if you had, maybe you could be doing some of this virtually. I mean, you know, Peloton, for crying out loud, invented maybe there were
maybe they were second
them,
yeah.
But I only pick on Peloton because I like Peloton. You know, they have the virtual workout. Everything is done in your house, and everything, you know, you're following the trainer on the screen. So did you try any of that? Well, the point is, this guy has done nothing, but now he's now he's seeing, we're going to end up deferring some of his rent so we actually gave him very good ideas, and he's going to try that. I hope we can get this thing resolved quickly for their sake, because we don't want to lose the tenant. And again, it all comes back to, we don't want to lose the tenant. You want that tenant there a year from now, 2 years from now, 3 years from now, so that number one, you have your income, and number two, when it comes time to refinance your mortgage, as I said, most of these mortgages have balloons that come up in 5 years, 7 years. Are you going to be able to go to a bank and get a loan if half your building is empty?
There's some people who joined, I said this before, but there's been some people who joined us late. So if you have any questions, you can always email me. My email is on the first slide, blink, B-L-I-N-K at MSGRB. Reach out to me directly. And then at the end of the day, maybe earlier than that, we're going to have a video link for this seminar. You can watch the whole thing over again on our website, and all the training materials on the website, so you can watch the whole thing over again. Commercial tenants are sophisticated parties, so they see the courts see the commercial tenant as Sean Connery. New York will not disturb the contractual relationship where a contract has been negotiated by sophisticated parties and its terms are clear and unambiguous. David, you kind of referenced that earlier. It's a kind of a tenet of New York landlord-tenant law that the courts don't want to get into every contract and renegotiate it over again just out of fairness sake. That if there is a meaning to be derived from the words that are in the negotiated contract that two sophisticated parties came together and reached, courts aren't going to disturb that unless you have frustration of purpose, or if it's an unconscionable contract or something to that effect. David, anything you'd add there?
No.
What if you got a provision in your lease that prevents the tenant from bringing any defense in an action for the non-payment of rent, David? How would you handle that situation?
Well, so again, any commercial lease that doesn't have that clause, the
landlord didn't do the job.
The attorney that drafted it didn't do a very good job, because all commercial leases that I've ever seen and ever drafted have that clause. But that's precisely what we're talking about today, with the impossibility of performance or frustration of purpose, the force majeure clause. We're getting around that clause by using these legal theories, again, to help us through a situation. And again, I remind everyone that what we're talking about today, the whole purpose of this webinar is to try to set everyone up in a position where they can reasonably and properly and purposefully renegotiate terms of a lease to get both of you through this pandemic.
All right, moving on to the next slide, Chapter 11 bankruptcy. I think I'm going to do a whole separate webinar on this. We only have so much time left, and I want to get to questions, but let's review it really quickly. I mean, a Chapter 11 bankruptcy, the good thing about a Chapter 11 bankruptcy is, the small business is in charge. The small business gets to come up with a plan of negotiating. They're the debtor in possession of the business. There's no trustee that's managing a business for you. You still have to consult with the creditors, and the U.S. trustee is involved and asks questions. But at the end of the day, you're going to be able to access cash collateral. You'll be able to get what's called the DIP loan, DIP funding, that gets priority in the bankruptcy. And you'll be able to come up with a plan. And if you qualify under subchapter 5, which was effective in February of 2020, and then amended in the CARES Act, you can really get through a bankruptcy confirmation relatively quickly. And if you qualify for chapter 5, which liquidated, secured, and unsecured debts can't exceed $7,500,000. That's under the CARES Act. That threshold of $7.5 million lasts 1 year, and then it will revert back to the the old standard of $2.7 million. That's something you might want to take advantage of if you are looking at bankruptcy, because you can very quickly get through confirmation. You can very quickly continue your operations and get access to cash collateral from your business. Also on bankruptcy, the other thing I wanted to mention is you cannot terminate a lease just by virtue of filing bankruptcy. You cannot force the landlord to modify your lease. The default will be able to be cured within a reasonable time, or the lease can be rejected. And then if the landlord wants to play ball, you both can renegotiate it and come out with an agreement that's best for both parties. Rejection equals breach, but the termination, the decision whether or not to renegotiate the lease, that's going to lay with the landlord. Okay, some other topics. Now, this is another thing that's it's a whole other presentation unto itself. SBA assistance. In fact, I've been working, over the last month during this crisis, and I keep seeing sometimes twice, 3 times a day, information about SBA assistance and different webinars. David, you want to give us like a $2 explanation of what's going on there?
Sure. There are probably very few small businesses that are not going to qualify for this. So anybody on this webinar that has not applied for assistance is very foolish if you don't try. It's part of the CARES Act. You have the Paycheck Protection Program, the PPP, which is if you use 75% of the funds, overall funds borrowed, for payroll expenses, and that includes all payroll expenses, and you are a small business, 500 or fewer employees, you can borrow up to $10 million, which essentially covers 2 months of your payroll. And if you do it the right way, it turns into a grant. So it's for free. And the purpose of this is to put payroll paychecks into your employees' pockets so that they can pay their rent and so that they can put food on their table. If you apply and don't use all of the money the way you're supposed to, not so bad either. It's not a grant. For the part that you didn't use properly, it's not a grant. And I've heard 2 versions. The one I like the most is it turns into a loan that has to be paid back in 2 years at 0.5% interest. Not too bad. Probably free money. The other part of the CARES Act is the EIDL, the Economic Injury Disaster Loan, and that too it will be 100% a grant if you spend it properly, and that is for rent. Well, I don't want to delineate every one of those. I don't remember them all, but just to give you an idea, it's all spelled out there. It's for rent. It's for internet, telephone, and again, that covers for 2 months. So if you're a small business under 500 employees, you can apply for both. Oh, and also under the EIDL program, you get a $10,000 emergency grant, which is not, you don't have to pay it back. So they're going to throw $10,000 at you. It's supposed to be within 3 days of applying. I understand that's not happening, but just to get you by until you can apply for the PPP and the EIDL loans.
So the reason why I wanted to mention that is because, when you're talking about lease negotiation, reaching out to your landlord, it's important to think about the clauses in your lease. It's important to think of what you see as far as a plan for your small business, or if you're a landlord, your plan for getting out of this. But you can't look at these things in a vacuum. You have to look at them in their totality. So you're looking at SBA, You're looking at, potential for Chapter 11 bankruptcy and what the Chapter 11 bankruptcy can do for your business. You're looking at those provisions in your lease. You're also maybe looking at insurance claims. So there's various types of coverage that might be in your business policy. There's business interruption coverage. There's civil authority coverage that ensures where government authorities restrict access to the area, which depending on how that's written in your insurance policy could be applicable. There's virus or bacteria exclusions. Now, it's not only important whether or not one of those provisions apply to your situation, it's also important that the actual coverage that you're getting. So, for example, that coverage actually applies. So, for example, if you have virus and bacteria coverage and only covers damage to the property, that's not going to help you very much in the COVID-19 situation. I think you're going to have a difficult time. I'm not saying it's impossible, but showing damages to the property. That's another thing to keep in mind. The other thing you want to also keep in mind is pending legislation. Keep a watch of what's going on, particularly in Albany. There's a number of ideas that are being shared. Generally, the legislature in the last couple of years has shown themselves to be pretty pro-tenant and willing to pass legislation that just a few years ago probably would never have seen a light of day. You got Senate Bill 8125A that essentially provides a rent holiday for 90 days. In fact, it says there's a rent holiday for 90 days with respect to any residential or commercial tenant. And if you're a landlord and you have to pay a mortgage, you get a mortgage holiday. Now, I don't see that. Listen, I'm not a constitutional lawyer. I'm not an expert on the Fifth Amendment or the Contracts Clause, but everything that I do know, I've been told since law school, is that that wouldn't pass constitutional muster. But listen, this is a unique situation, an unforeseeable situation, as we discussed. So whether that changes, whether the legislature and ultimately the courts see it a different way remains to be seen. There's Senate Bill 8139 also out there, and what that's endeavoring to do, it's also an interesting proposal, which I'm not sure is constitutional, and I'm not sure if it's just an idea that's being thrown out there, or if it's really being taken seriously. It is sponsored by influential members of the Judiciary Committee in both the Senate and the House in Albany. But what they're saying there is you can pay your rent or whatever is less, 30% of the profits of your business. And then in the case of a non-payment, essentially the judge, so the landlord, let's say, sues you for only paying, 50% of your rent. 50% of your normal contractual rent, they bring a non-payment action for failure to pay rent. Under that legislation, you'd be able to plead as a defense that you complied with the terms of that proposal, and then the judge would have an in-camera review of your finances. So this is going to take months to shake out. The legislature isn't even meeting right now. I think they've had some meetings via Zoom, but it's something to keep a watch of. Another idea that I thought might actually get some attention is permitting tenants to use their security deposits towards the rent. I'm not aware of whether or not that's an actual bill. I have heard the idea bandied about by several politicians, so that's something to watch out for. I think it's something that's actually a possibility. I'm going to open up everybody's microphone right now, and if you have a question, if you don't want to mute. If you don't want to talk and you want to type out a question, you can go ahead and do that.
Just be careful when you're, don't talk over one another. That happened in many webinars.
Yeah, if you feel more comfortable, you can just go ahead, try to unmute yourself so I don't have to do it personally. And then if you have a question, go ahead and ask it. We're here for the next 10 minutes to answer any questions that you might have. You can mute yourself, you can unmute yourself, you can type a question. And just go ahead, fire away. While we're waiting for a question, I just remind everybody, I saw people joining in as late as about 10 minutes ago. This entire presentation, we're going to make it available, probably not the question section, but we'll make it available on the website for you to view later. A lot of people logged in late, so you can watch the whole thing again. Hopefully it wasn't too dense for you. You know, if you have any specific questions or you want to talk to me about a consultation, you can reach out to me. My name is Bobby Link. My phone number, I'll give you my cell. It's 516-417-4545, 516-417-4545. The best way to reach out to me, on the first slide of the presentation, my contact information is there. The best way to reach out to me is Blink, B-L-I-N-K, at msgrb.com. Again, that's Blink, like blink your eye, at msgrb.com. So you can reach out to me, ask for a consultation. Anyone have a question, you know, who's waiting for us? I think we have up to 26 participants right now. So,
Hello.
oh, okay. I have a, okay, here's a question, David. Hi, Bobby. I have a new lease. I signed in March and I have some free time until May. Wait, do you want to finish? I think, is that a full question? I have a lease signed in March and I have some free time until May. I don't know if, oh, okay. My rent starts in June. Go ahead. If you have a, I'm going to wait okay. All right. Here's the question. Hi, Bobby. I have a new lease signed in March. I have some free time until May and my rent starts in June. Can I ask for a waiver? Yeah, you can ask for a waiver in June. You can ask for anything. You could ask to cancel your lease. David, what would you do in this situation?
Well, look, you have the forgiveness of rent at the right time. And if you don't think you're going to be in a position to pay the rent, I don't remember if it was through June or through May. If you don't think you're going to be in a position to pay the rent in June, sure, I would go back to the landlord and tell them you need more free time. And the question becomes, is it going to be abated where you don't have to pay anything? Or is he or she going to say, I'll tell you what, I'm not going to abate it, but I'll tag on another 2 months for free for now, but we're going to defer it. And presumably you're going to be up and running next year. And I'll let you pay those 2 months from January through December next year, which should make it easier for you. I don't know what kind of business you have, but hopefully you're going to be up and running by next 2021. So that's always an option. And again, I would suggest, well, you said you started your business in March. Unfortunately, I'm pretty sure you're not going to be able to apply for relief under the CARES Act. I think you had to be in business either on February 1st or February 15th. I have to take a look.
You know, as far as your negotiations with your landlords, they're exactly that. It's a negotiation. So you want to use what leverage you have in the situation, and you're going to explain, listen, I can't pay, or this is the situation, and they're going to look at their timeline for eviction, and they'll make an agreement. We're coming up on an hour now. I don't know if we get kicked off, or but if anyone wants to try to ask one more question. I have another chat question. Hey, Bobby, our lease ended after 3 years back in December, and we're on month to month. It's a full service salon. Can we ask for rent forgiveness? Yeah, you can ask for, see, when you have a month to month lease, that's what it is. It's a month to month lease, and the landlord doesn't need, they're going to keep you there, for the remainder of June, July, August anyway. In all likelihood, and then it could be extended beyond that just by virtue of the executive order of Governor Cuomo as this goes on. But if it's a month-to-month lease, the landlord is going to be able to evict you with a holdover action anyway. So they'll just serve a notice to terminate the lease at the end of the month, and then they'll get you back in court relatively quickly. You won't run into the same issues and the same defenses that you have with respect to the non-payment and the force majeure and frustration of purpose. If they want to terminate your lease and the lease is over, and they don't want to continue the month-to-month lease, they should be able to go ahead and do that.
Yeah, really, your lease is over, so you're a month-to-month tenant. So it's not a matter of terminating the lease. It's just a matter of if they want you out, you'll be served with the appropriate notice, and then they can bring a holdover action to get you out. You're in a very good shape right now, though, because that's not going to happen for a while, and you don't even have a lease that's obligating you for a certain period of time in the future. So, I guess if you came into me, I don't know if you want to stay there or if you're going to move someplace else and you have a reputational risk where, you don't want to leave on bad terms with your landlord. You may want to work something out. You'd like to stay there. Okay. So if you'd like to stay there, then you want to keep it on good terms. And, obviously right now you have no customers. And this is kind of like the example of the deli. Well, I guess you're going to have a lot of customers one day. But are you going to be able to recoup all that income that you've lost for the days that your door has been shut? I don't think so. So, in your instance, if I was representing you, I would argue for an abatement of rent and a deferral of the rent. And maybe this is a very good time that you should be renegotiating your lease. You could probably do very well with the lease now because especially if you're going to agree to pay some rental to the landlord, because right now they're sitting there, they don't know when they're going to see rent again. They don't know when the courts are going to open and allow them to start enforcing these contracts again. So you're really sitting in a very good position, especially if you want to stay there, and especially if you want to renegotiate a lease.
Any other questions? Anyone else, written or audio?
You're welcome. Bobby, does this have to end at 3 o'clock or?
No, apparently not, because I think we're after 3 o'clock.
So if you have questions, please feel free. I know Bobby and I tried to do a good job, but we couldn't have done that good a job that we answered everyone's questions.
Again, if you're not comfortable asking the question now and you want to reach out to me, my email is blink, BLINK, @msgrb.com. I can talk to you informally. We can set up a formal consultation with David.
All right. So it's the question just asked, is it better to renegotiate the lease? And the answer is yes, if you want to stay there, that's what I would do. And you have the landlord in a more vulnerable position. The question was up there, Bobby, but it's gone.
I know, I see it. Hey, I'm a tenant of Kimco Realty. They deferred our April rent and told us we have to make the monthly installments starting September 1, 2020 and continue until August 2021. Well, it sounds like, and David, you correct me if you're reading this differently, we are a non-essential business, so we're closed. It sounds like Kimco Realty did what I would do if I was a landlord attorney, is try to say, hey, we're being nice guys, we're going to lock you into a forbearance. You're a non-essential business, so you're closed. So your purpose has been frustrated, and I'm not using that. I'm using that colloquially and not as the term of art that we've discussed. So you're somebody who wants to look at your contract and see if you have maybe even hire legal representation to look at the facts and start a negotiation with your landlord.
It sounds like they did you a solid. I don't know if they put it in writing or not, but it sounds like they did you a solid. I think they did it in totally the wrong way because they could get hurt by this. Really, what are the terms of? They did put it in writing, and is it a detailed forbearance agreement? Do they outline exactly what they're doing, for how long they're doing it, and okay, so then you're good. That's a great situation. They gave you an abatement of rent. for
No, I
quite.
don't see abatement. I don't see an abatement there.
Well, that's, I thought he said that. I thought they said they were forgiving the rent.
They deferred our April rent.
Did you say defer or forgive? I don't.
I'm reading the question. They deferred our April rent and told us we have to make the monthly installments starting September 1. So they're not getting an abatement under the
Well,
deal.
so if they deferred April, what about May, June, July, August? That doesn't make sense. In other words, if you have to pay April, what about May, June, July, August, September, May, June, July, and August? What's happening there? Were those months deferred, and they want you to start paying it in September? Well, okay, you haven't discussed about that yet. All right, so that's exactly.
Sounds ripe for negotiations.
It's horrible. It's horrible. So it's more horrible for the landlord because if I'm the tenant, I'm going to argue. You said I didn't have to pay rent till September. I'm not paying you any more rent. It's not going to do much for your relationship with the landlord. But you see, it wasn't done right. You know, you want to make everything. I mean, you know, this guy did, or this person. They did exactly the opposite of what I suggested. You know, you should enter into a pre-negotiation agreement so you outline exactly what you're trying to do. And then you go through the steps we talked about, and then you end up with a nice agreement, a nice forbearance agreement where there are no questions. Everybody understands exactly what's going on. Nobody's rights are waived. You know.
All right, next question. I have a physical therapy, 3 offices, 2 office. I have no idea when we can be back to work and make the money. I just got an invoice for the rent. What's my first step?
Well, the first step is to call your landlord, and he should or she should be reaching out to you. I have clients that are reaching out to their commercial tenants, trying to stave off complete non-payment of rent. But you should reach out to your landlord and go, look, it's physical therapy. This is not something I can.
Can't do anything physical.
You can't do, yeah.
Right.
I mean, I don't know if you could do
There's
it.
no virtual therapy.
That would
yeah,
be,
right.
Yeah, but that would be very difficult.
Right.
So, you know, I am out of business. And if you want me around when this thing ends, we're going to have to, you know, we're going to have to do a rent abatement because I'm never going to be able to make this up. And you should go through this process. You should enter into a negotiation. I would do it with attorneys so that, you know, it gets done correctly, and you don't end up with a lawsuit later on. I mean, the whole idea of doing a good agreement, one that's going to stick, is so that you prevent lawsuits later. So I think you're a perfect example of reaching out to the landlord and working out an agreement which has the rent being abated until you're able to get back on your feet. And I hope you have applied for the under the CARES Act to help you out, because you know you can get 2 months rent. Under the CARES Act.
So, thank you for answering my question, Robert. This is Dr. Desai. So I know that they said that I can use that money once I get the approval for the care under the CARE Act. So do I have to ask the landlords to hold their bills and make it deferred payment, or ask for an abatement?
All right. So
go ahead, David. We were talking about this hypothetical earlier yesterday.
You can apply under the CARES Act for the 2 months rent. Okay, that's easy, and you'll also get a $10,000 stipend that you don't have to pay back, just to help you through this time. That has nothing to do with what you're going to be doing with your landlord. I would work on both fronts. I would apply through the CARES Act, through the EIDL, and get your 2 months rent that you're entitled to, along with telephone, internet, and whatever, and your $10,000 stipend, and then go back to your landlord and say, look, you know, I need an abatement for a certain period of time. When I get the rent through the CARES Act, the 2 months rent, I'm going to pay you that, but then I'm going to need other rent forgiveness because I'm not going to be back in business probably until January. you know, or the fall or October, November. So you can work on both fronts. You tell the landlord, I'm going to get you 2 months rent because I'm applying under the CARES Act. And when I get that money, I'm gonna pay you, but I'm going to need other forgiveness. And at least that's showing good faith. If I'm the landlord, I'm like, okay, great. Apply through the CARES Act. Thank you. You're going to get me 2 months rent and I'll work with you on the rest.
Right. Right. Okay. Thank you so much for answering the question very efficiently.
David, there's another question. Thanks for the question. Another question in the chat. My previous location, I was supposed to surrender by March 20th, and we hardly had any business in February and March. We couldn't surrender the store on time, but the landlord acknowledged that we can do that when we all return. My question is it possible to get a forbearance for February and March rent?
I mean, I don't see why not. You're not operating out of you're not operating in a new location and you have no business right now. Again, the concept of a forbearance is that you're working with your landlord and the landlord's working with you. Now you're leaving, so there's no incentive. You're not going to be there in 6 months, 8 months. You're going to be out of there as soon as you're able to move again. Which is fine, but the landlord would still like to get those 2 months rent that you haven't paid. So if I'm the landlord, I'm going to make it very easy for you to get to pay that rent back to me. You want to pay me back in December or I don't know what your circumstances are, so I don't know when you'd be able to do it, but certainly any remedy which gets your landlord their rent and it gives you the ability to stay put until you're able to move again is a good outcome. Somebody asked me the other day, I have a new tenant going into a premises and my old tenant was supposed to be out. I think they were supposed to be out they were supposed to be out the end of March. Sounds like something very similar to your situation. There was a clause in the lease which provided that if you were a holdover tenant, you had to pay twice the amount of rent that you were paying for the holdover period. And the landlord, the tenant, sent the landlord a check for the 1 month's rent, but not the double the amount, saying that this is a force majeure. And I can't move. Therefore, you have to take the 1 month. That's fair and reasonable. So the landlord came back and said, "What do we do?" So I called I actually wrote to the tenant. I sent the tenant an email, and then the tenant's attorney came back to me, and we were talking. And I said, I don't know necessarily that this is a force majeure. I'm taking a position, okay? And I said, but the commercial landlord-tenant parts are open for emergency applications, and I consider this an emergency application where I need you to get out of those premises because I have a new tenant that's going in there, and if I don't get them the premises by a certain date, I'm going to lose that lease. Not only that, your client has chosen to take that liquidated damages clause. We're saying that if you're in there in the holdover period of the lease, lease ends and you hold over, and the lease provides if you hold over, you have to pay twice the rent. That's really a liquidated damages clause. I said, your client, in sending us the 1 month's rent, saying that that's fair, and you're not going to take advantage of the liquidated damages clause, tells me that they've waived the liquidated damages clause, and now your client is on the hook for whatever my client's losses are, and I agree to that. So with that, I get a phone call back. They'll be out by April 15th, which was fine with my client. We just wanted to get them out. So, I don't know if I answered your question, if I went too far off. Okay. Can you apply for 2 months? Yeah, you were for February and March. Yeah.
The question is for I don't know if everyone can read the chat. Can you make an application for 2 months rent through EIDL, which is the SBA program? Go ahead, David.
Yeah, the answer would be yes. The answer would be yes.
Any other questions before we close up? Anyone else? Okay. Well, again, you can reach out to me. We're David A. Gallo and Associates. Reach out to me via email, blink, B-L-I-N-K, at msgrb.com. My cell phone, 516-417-4545. These materials will be on our website at www.dagallp.com. Hopefully later today. Thank you so much for listening and for your really thoughtful questions, and good luck.
Good luck, everyone. Stay well.
Thank you.
All right. Bye-bye.